5 on Zoom, and I think few in this classroom. So we'll be very happy to receive your questions at the end of this lecture. So thank you, Charles, for the invitation. And also, since this lecture is recorded, I would love to hear from you first about the Comparative Law Society. How did you establish it? And also, basically, the main reason for this society, because I'm going to share this video recording with my students at Al Faisal University, and hopefully we'll have also a similar Comparative Law Society. So if you can, please just briefly talk about the Comparative Law Society, and then we can start with the lecture. Charles?
The Comparative Law Society, introduce it?
Yes.
Well, the Comparative Law Society was founded last year by Carlos. I can't pronounce his last name. It's Spanish, Chilean. I can't figure it out. But he's a very dear friend of mine. And you are actually the first speaker of the year for us. The Comparative Law Society is specializing in broadening the horizons and understanding of particularly American students regarding the differences between different legal structures, different statutes, and different procedures, from common law to civil law societies, civil law jurisdictions, and also, frankly, providing a method of and means of cultural exchange between different countries and different people from different countries. And it's actually been very valuable for myself, and I think it'll be very valuable for everybody else in this room, particularly the comparative aspect, because of how important it is to have something as a means to compare yourself and other places with. And this is for me, the meat and bones of international law, not just people's experiences in different countries, but also understanding very deeply how those different systems work and how they can be harmonized together. Is that about, I think about wraps about everything.
Excellent. Thank you. Thank you very much. Thank you very much for this brief summary of the society, and hopefully my students at Al Faisal University will have a similar society. We have the law students associations, and their main focus now is international mooting competitions, but I think it will help to have a society of comparative law and do the same great work that you are doing. And I think you are also going to host Professor Marco next week. We need international humanitarian law professors like him with his very good insights on international law. So I will start by, now I'm clicking and it's, okay, you can see the slides now. Great. So why comparative law? So I think it will help that since I'm the first speaker for the society to talk also about comparative law before we start talking about international contract law. So why comparative law topic and also discussion here? The reason I've been an academic for the last 7 years, teaching both in Arabic and English, and my legal background is international trade law. I did my PhD and master's in the UK. So from my academic work, teaching different civil law courses, and also this new phenomenon in the Middle East, we have these mixed law program where they try to combine common and civil law. And just as a general knowledge point for you, that most of the Middle Eastern countries actually are civil law based. So in these mixed program schools, they teach different courses of common and civil law. And in my current academic position at Al Faisal University, I'm teaching Saudi laws in English. I'm teaching Saudi civil laws in English. And to me, comparing basically different laws and different methodologies, I became gradually interested in comparative law for both practical and also for research reasons. So this is a phenomenon. I mean, if you can look at some of these international law schools in the Middle East, for example, in Dubai and in Saudi, where they try to combine the common law and the civil law. And this is also another important point that I need to mention at the beginning, since we're going to talk about civil law a lot in this lecture, that most of our actually civil laws in the Middle East are based on not in Islamic law, but they are actually heavily influenced by French law. And one of the reasons that they are heavily influenced by the civil code, the French civil code, because a well-known jurist, an Egyptian jurist called Abdurrazzaq al-Sanhuri, who codified most of these civil codes and civil laws in the Middle East. And he also, for example, in Saudi, we have a new civil law that was issued just last year in December, a very comprehensive law, more than 720 articles, regulating different aspects of contract law. So basically, this is the applicable law now, which in a way kind of complements, not replaces, but complements Sharia principles. So for me, legal education, the new phenomenon of these mixed law programs, curriculums in the Middle East, where the West meets East, where common law meets civil law, where Islamic law meets, different kinds of national and international law. The second reason that got me interested in comparative law is international mooting competition. So I have been coaching for the last 3 years, coaching both Vismoot teams and also Arabic moot teams, which is the Saudi Center for Commercial Arbitration. And what we have encountered as coaches and also as students and researching these different research questions for the moot is that we need comparative law. We need comparative analysis to answer many of these applicable law questions. And I will identify at the end of today's lecture the different aspects of why international law has become, as one of them, Canadian professors article says, international arbitration is comparative law in action, or as comparative law in action. The third reason for comparative law, an interesting comparative law, is the study and practice of international arbitration itself. For example, I'm doing this CR fellowship, module 3 now. And what I saw in module 2 is that when they basically for international arbitration, just in a nutshell, the CR fellowship is basically, this is the professional certificate awarded by the Chartered Institute of Arbitrators. And many of these international arbitration centers around the world, including in the Middle East, they require either to have an experience with 4 or 5 arbitration cases or to have the fellowship certificate. And the module 2 of the fellowship is on the law of obligation. And interestingly, in this very comprehensive textbooks on the law of obligation, they use comparative law. They use different laws, and they ask us basically different questions to answer them for assessment reasons. For example, the law of obligations on contract and tort cites UK, Singapore, German, UAE, China laws, etc. So these are the main 3 reasons for my interest in comparative law. One, as an academic; second, as a coach of mooting competitions; and third, as a student, current actually students of international arbitrations, this professional certificate of CR fellowship. So I will start this presentation with a proposition. The foreign lawyer or a lawyer using foreign law is knowingly or unknowingly using comparative law methodology for the study and practice of civil law, including the practice of settling contracts of sales disputes. The foreign lawyer is a comparativist. And I intentionally use foreign law, not international lawyer, to differentiate basically between, a foreign lawyer based in, let's say, in Dubai or New York, than someone who is applying different international laws, trade or criminal law. So this is the proposition of this lecture, and I will try, citing different sources. And I will also, at the end of this lecture, I will share these slides with references. I will share them with Charles. Sorry, just clicking. Okay. So what is comparative law? There are different sources. I mean, most of them talk about comparative law as a discipline, talk about comparative law methodology. So starting with this textbooks or a small short introduction on comparative law, usually it's basically, it's from a linguistic basically definition. It's basically a comparative assessment of entire legal systems in order to unveil similarities and differences. And also you can think of comparative law for different purposes or different reasons. For example, the second definitions to me is legislative reasons, that for legislative purposes, including when my government, for example, last year, when they tried to issue the Saudi civil transaction law, the jurists and those who are basically the legislators who work with them, they compare different laws. So this is also, this basically fits the second definitions of this comparative law, the study of how legal solutions are imitated, transplanted, accepted, and rejected in other countries or social groups. So you can see basically it has a legislative purpose, it has an academic purpose, and you will see also at the end of today's lectures also have a practical purpose, or basically applying comparative law in different practical reasons or practical purposes. For example, in arbitration, or for example, legal advice, etc. Also, comparative legal analysis, and we will see from the origins of comparative law, comparative legal analysis has many targets, but the 2 common ones are the unification and harmonization of law, and also legal convergence. And we will see that very clearly when we talk about the founders of comparative law and their main projects of unifying private law, harmonizing and unifying private law internationally, not only in mainland Europe. So these are the two common targets or goals of comparative legal analysis: the unification and harmonization of private law and legal convergence to aid trade and commercial purposes. One of the well-known jurists of comparative law is Ernst Rabel, and he was a member of the UNIDROIT principles. And I think I mentioned in passing the UNIDROIT principles, just clicking here. The UNIDROIT principles of international law. So these are the two, the CISG, the United Nations Convention on Contracts for the International Sales of Goods, and the UNIDROIT principles of international commercial contracts. So what we found from reading the literature is that many of those jurists who are the founders of comparative law were engaged with these projects of unification and harmonization of international private law, mainly the international contract law, international civil contracts. And one of them was Ernst Rabel. So this is, I mean, you can see all of those names of different founders of comparative law in a way where almost all of them, the students of Ernst Rabel, and also one of the latest professors of comparative law, he was based at Cornell University, all of them were engaged in different or conducted different private international law, private national laws research in contract and tort. So you can see basically, I mean, this is also well established in the literature that private law, mainly contract and tort, is still the main subject area of comparative law. And by some jurists, it's regarded as limitation, because we need basically to use comparative law for criminal law. You need to use comparative law or comparative law methodology for different kinds of, for different laws, for different reasons. Also, comparative law main achievements is the harmonization, as I mentioned, of private international law with contract principles that transcend legal cultures. And I can see that very clearly, with the CISG, with the UNIDROIT principles for international commercial contracts. The CISG basically, can be used as the applicable law in many of these international contracts. If you can find, an arbitration tribunal or a country that basically has ratified for example, the CISG or accepted the UNIDROIT principles as one of the bases for their civil transaction law, and you have judges and you have also arbitration tribunals citing and reading these very important legal instruments that were drafted by jurists and professors of comparative law. Also, one thing that unify all of these names is that most of them actually come from Germany, because German professors are well-known jurists in comparative law, and they have, especially those private international law professors. So usually when we think about comparative law, and as you can see from this, the second paragraph, making comparative law as a discipline requires an accredited methodology. Making comparative law as a discipline requires an accredited methodology. And from my reading of the literature, you can think of methodology as a doctrinal methodology for legal research, but also comparative law methodology for legal practice. So usually there are 3 or 4 main accredited methodologies of comparative law. First one and the traditional methodology is this functionalism methodology. There is also legal culturalism, universalism, etc., etc. So these are well-established methodologies of comparative law. But we will see at the end of today's lecture, citing 2 sources, that you can also see or perceive comparative law as a methodology for practice, how to practice, how to compare laws for research purposes, but also how to compare laws as a practitioner when you give a legal advice, or when you arbitrate, for example, when you arbitrate a dispute. The first also preliminary point before talking about methodology is that categories and concepts are not fit for making comparisons, because concepts, and this is an example from this concept of contract, it has different meaning, different connotations, different attributes in different jurisdictions. For example, contract in English law is different from contract in French, because the former does not include donation. And I know that, as an academic, because as I mentioned earlier, our Saudi civil transaction law is heavily influenced by French civil code because of, Abdul Razak al-Sanhuri's, this one of the main founders of civil codes in the Middle East. So we have, if I am comparing, for example, the Saudi laws, the Saudi civil transaction law, the similar law that's basically comparable to our law is the French civil code. Whereas for the English contract law, it might be different because these different terminologies can have different, as I said, attributes and connotations. And the comparative, it's the lawyer, the foreign lawyer, the arbitrator must be mindful of these limitations or this very important preliminary point. Also, as I mentioned earlier, one of the definitions of comparative law can be used for legislative reasons. And this is a quote from Ernest Rabel. We compare the solutions produced by one state for a specific factual situation with those produced by another state for the same factual situations. And then we ask why they were produced and what success they had. So this is, you can see, that can be used for legislative purposes or amendment or legal reform, and also can be used for a comparative law. And you can use the same methodology for comparing contract law and contract rules. So starting with, and today I'll just focus on the main methodology of comparative law, or the traditional method of comparative law, the functionalist or the functionalism method. So basically what most sources in the literature say, basically it's comparing the functions of similar legal rules. So that's where the word function comes from. But it has its own limitation. And I will also add, a clarification on this limitation that only comparable or like legal systems can be compared, but a comparativist must carefully study the foreign law before excluding it. And the reason I say it must study the foreign law before excluding it, because sometimes you have these misconceptions about certain laws. For example, as I mentioned earlier, some people, even well-known professors will say, for example, Muslim majority countries or countries in the Middle East, they don't have a civil code. Why? Because it's all based on Sharia. When in fact, almost all Muslim majority countries in the Middle East, most of them now, they have a civil code, codified civil code. And as I mentioned, most of these codes are actually based or heavily influenced by the French civil code because of the history of codification of this law in the Middle East. So almost all Middle Eastern states' legal systems are civil, and their civil codes are influenced by the French civil code, which make them comparable to European civil codes, also in different ways comparable to the two dominant legal systems in the world, especially if we are talking about contract law. They are also comparable to common law or common law rules and concepts. So starting with an example, so I will use two examples, one where functionalism can be useful, where functionalism can tell us basically the differences and can be useful for academic research purposes and also for practical purposes. The second example where functionalism is inefficient or ineffective in comparing two different laws because of this criteria or this important preliminary points of comparable or like legal systems. So as you are familiar, as a JD student, you are familiar with the rule of punitive damages, exemplary damages. Here citing the California Civil Code, has been guilty of fraud, malice, and the plaintiff basically, in addition to the actual damages, may recover damages for the sake of example and by way of punishing the defendant. So as a general rule in civil law, we have no punitive damages. Punitive damages are prohibited, and punitive damages, I will see later, punitive damages has different terminologies and it's linked actually in most jurisdictions to criminal law or criminal liability for the defendant. So if you are doing a functionalist research and using the rule of punitive damages, then the first question you will ask is, what are the tools other countries use in order to deter and punish breaches of private law obligations? And in order to do that, as someone who is using this functionalism methodology, is also to ask a sub-question and to find basically the answer to that sub-questions from comparativist research. What is the most effective legal system? Because that's mainly the purpose of comparison here. What is the most effective legal systems in solving a problem? So we have, for example, almost in all jurisdictions, there are people who doesn't care about the sanctity of contract, that they use fraud, that they use malice, oppression, etc., and they will breach the contract regardless. So what other mechanisms or tools other jurisdictions use to deter these types of egregious violations of contract? So you need to, for example, citing from my own country's law and also civil laws in general, you need to think of different terminologies. For example, punitive damages in civil law does not exist per name, per se. They have different names. And through these different terminologies, you can actually, find punitive damages, or you can find your client or your, the claimant can find basically reasons to ask or claim for punitive damages. The first point is that in most civil transaction laws, and the reason I say most civil transaction laws or civil codes in the Middle East, generally because they are similar. They're almost like some of them are identical. You have these very long laws, 700 articles or more. They more or less use the same basic terminologies, article, etc. So, for example, in civil law, one of the terms that is actually very important and repeatedly mentioned in the civil codes is bad faith. So, basically, a party who has been acting in bad faith, he will be found contractually liable. He will bear the responsibility for the breaches that he has committed. Also, in terms of terminologies, compensation. Compensation is basically the alternative term to damages. So if you as a plaintiff or a claimant and you want to file a case against a bad faith actor who has used fraud, oppression, malice, etc., then you can claim for compensation. The second point is that in most civil law jurisdictions, civil liability is linked to criminal liability. The judge himself has both the discretion to refer the defendant to criminal law or find him criminally liable in the civil case because of the harmful act that he committed, and also because, for example, fraud, etc. If he used fraud in drafting a contract, etc., he can penalize basically the defendant, and in a way send a signal to the claimant to say that you have, the defendant basically has acting in a malicious way, and he therefore should be penalized and should be subject to a penalty from criminal law. So in a way, civil liability in civil law is linked to criminal liability because the judge has a discretion to cite both or to try, to find him criminally liable for fraud in commercial transactions. For example, I cited these two articles from the civil transaction law. Civil liability shall not prejudice criminal liability. A person shall be liable for any harmful act he commits. So far, there's no mentioning in the civil transaction law of punitive damages, but I'm trying to find, legal rules, similar or comparable legal rules to help me as a comparative law researcher to find basically similarities between the two, and to see for legislative reasons, for also research reasons, and also for practical reasons as an arbitrator, for example, encountering these two different laws, what is the best law to address these or to deter these serious violations of contract? Also, in the Saudi companies law, for example, any person has a right to claim a compensation from any party causing damage. So, also gives the plaintiff the right to claim damages, especially for, causing damages. Because interesting, I think some of you might not know that in civil law jurisdictions, including in many of the jurisdictions in the Middle East, we don't have punitive damages. We don't even have a tort law. Usually our tort laws or tort rules are found in different jurisdictions and different laws, and they can be interpreted differently by different judges within the limitations of the law. So this is an example where, this is the example, just go back, clicking. So this is an example where functionalist research work. Now, the second example basically is functional research is ineffective because the laws are incomparable to the specific contract on the specific contract issue. And I cited here the CISG and the UNIDROIT principles to say on the issue of non-conformity of goods, and this was one of the substantive law issues that was discussed and debated by more than 300 teams last year in the Bismuth, the non-conformity of goods. And the claimant basically is saying that the CISG is the applicable law to the non-conformity of goods issue, whereas the defendant saying, no, the UNIDROIT principle is the applicable law. So these two laws are incomparable when it comes to this issue, the non-conformity of goods. So you as an arbitrator, you as a researcher, you cannot use the UNIDROIT and the CISG on this issue of non-conformity of goods. And the reason is that the CISG fully regulates non-conformity of goods under Articles 35 to 44, whereas the UNIDROIT principles does not. There's only one article some authors say it has relevancy or it can basically be useful for consideration or for comparative analysis. Article 516 of the UNIDROIT principles, a party is bound to render a performance of equality. that is reasonable and not less than average in the circumstances. So this is the only article that I can find, and also another author found, that says basically that it can be used for non-conformity. So in this case, basically, you can say that the CISG is the best law to address this issue, but for academic research purposes, it's not, it may not be useful. So for you as an arbitration tribunal or as an arbitrator, of course, you will have a preference, you have a discretion. It's within your power to select the CISG over the UNIDROIT principles to address this issue of non-conformity. And in this case, stating your reasons and citing the evidence, etc., etc. So this is, for academic research, it might not be useful, but maybe for practical research, for practice, it might help to know the difference between the two laws as an arbitrator and to apply the most applicable or the most appropriate law to address this contractual or the substantive issue. So I will conclude this lecture with two methodology in practice, or two practical methodologies, citing two sources. So the first one is Edward Burley methodology, basically applying comparative law to a foreign law. So I mentioned the Saudi, for example, civil transaction law. You can think of different laws. So how would you use comparative law methodology in the practical steps? How would you use it basically to, to understand the different methods, the different, nuisances of this law for different reasons or for different professional purposes? So he has these four steps, and he wrote in a very interesting articles. And as I mentioned, all of these sources are mentioned at the end of these slides that I will share with Charles. So he mentioned 4 steps. First, as a comparativist, as a foreign lawyer practicing in a foreign jurisdiction, you need to acquire the skills of comparativist in terms of, emerging legal culture, linguistic knowledge, application of neutral, objective, and evaluative skills. I think from the example that we have used when it comes to punitive damages, linguistic knowledge was very useful because damages has no equivalency in English or in Arabic. The only equivalent term is compensation, and it's used in different contexts differently. So that's why, legal culture here, knowing the importance of legal culture, it always helps the comparativist, always helps a foreign lawyer. Secondly, evaluating law, evaluating stated law. And I think maybe maybe you know that as a public knowledge or from your study as a JD students. I found California civil law. My understanding as a purely civil law international law specialist is that there is no codification of contract law in the US at all, but we have a California civil code. There are different laws, stated laws, that can be used to compare it to different jurisdictions, different systems, and you can basically use it can be found useful for comparativist analysis. So differences in terms of contract law and the review. Third step is evaluating the law as implicit or internal. Edward used this internal dimension of law, and what I think he means the origins of the law. And also, if you use, for example, the civil transactional law, the origins of our most of our civil transaction law is Islamic law. And in the codification law and in the codified law, one of the articles, which is a very interesting article, it has rules on interpretation. Almost like 41 rules on interpretation, how to use these different rules of interpretation for your as a judge or as a lawyer. So it always helps as a comparativist to also evaluate the internal dimensions of law, the origins, the influences, in terms of religion, ethics, interpretation, translation, etc., etc. Lastly, determining the comparative observation. So basically the conclusion. What is the conclusion for you as a researcher, as a practitioner, when you have compared these laws, when you have basically the comparativist law, so the comparativist skills, and you have compared stated laws, your basically conclusion. What is the outcome? And as we have stated before, what can be learned, what can be used, what is the best outcome, and what is the best rule to govern the specific contract issue under question. The second and the last source that I want to conclude with is, and Charles might be pleased to hear that, from a professor from a Canadian professor, Joshua Carton, and he published this article in 2020 entitled International Arbitration as Comparative Law in Action. International Arbitration as Comparative Law in Action. And his argument basically is that comparative law thrives in the field of international commercial arbitration, because comparative law methods are employed at every stage of the arbitration. And it's very interesting, actually, article, and I recommend you to read it. It's like 35 pages, where he said basically in every stage of the arbitration process, international commercial arbitration, the arbitrators, the counsels, or the lawyers for the parties, they use comparative analysis. They use different methods, as I mentioned in my propositions, knowingly or unknowingly. So even he said that for the drafting of these international rules or soft law in international arbitrations, the drafters of these soft laws actually use comparative law. For example, he cited the IBA rules on the taking of evidence in international arbitration. So why did he make this argument? Why would the tribunal use comparative analysis? And I try to summarize. It's a very long article. I haven't read all of it, but it's excellent piece, where he used different reasons to explain basically why would the tribunal, or why should the tribunal use comparative analysis? Why should they draw in different sources of comparative law methodology? I mean, from reading his article, I can see that he's in favor of functionalism, also plus legal culturalism. We don't have time to explain what legal culturalism is, but functionalism in terms of valuing and deciding different questions of applicable law to the procedural issue, or applicable law to the substantive issues. So these are the main, usually these are the two main issues that arbitrators encounter, and also parties have a dispute over. So the first is that a party may choose a contract that's outdated or underdeveloped. Let's say, for example, the contract has been concluded like 10 years ago, 20 years ago, and the applicable law there is outdated. It's not developed to help the tribunal. So in this case, they might look for alternative rules or principles. And he even cited lex mercatoria. He cited the UNIDROIT principles, etc., that might be useful for the tribunal's consideration. Or the parties may choose to be governed cumulatively by the law of two states. So here, because interestingly in his article, he identified two phenomena: the phenomena of too much law and the phenomena of too little law. So what he basically says that these are the two situations that the arbitral tribunals encounter. And in these situations, basically, they either have too many applicable laws to substance and procedure, or too little, where the parties basically did not agree, or the parties where the applicable law clause is vague or incomplete when it comes to deciding which law should apply to the contract itself. The second reason is some substantive laws of contract don't govern all aspects of commercial relationship, so supplementation is required. For example, he cited the UNIDROIT principles. If you have an international contract and the applicable law is the UNIDROIT principles, it might be found ineffective or insufficient to help the tribunal. So in this case, they must look for different laws to govern the contract to help them adjudicate the disputes and find. And as one of the main functions of arbitration, or purpose of arbitration, to find a binding, final, effective, to make a binding, effective arbitral award. Lastly, with too little law situations, the tribunal is forced to find a contract law that comports best with the parties' presumptive intentions and expectation. So basically, the tribunal, in his analysis, is searching for the rules most appropriate to parties' circumstances, searching for the rules most appropriate to parties' circumstances. So this is a comparative law in practice, in the practice of international arbitration. As I said, one of the main weaknesses of, if there is a weakness, one of the main weaknesses of Joshua Cartman's article is that he told us when arbitrators will use comparative law, but he did not tell us what kind of methodology they will use. I think from reading it very quickly, he is in favor of functionalism, but could we use, for example, as a research question, could we use other different accredited methodologies of comparative law in the practice of international arbitrations? Because this issue of applicable law is almost encountered in almost all, in many international arbitration cases. So which basically, it's a very interesting piece. It's published in 2020. So it's basically the beginning of hopefully an interesting research for him, and also for those who are interested in international arbitrations and how it relates to comparative law. So these are the references for this lecture, and I will be happy to answer any of your questions. And I will also, as I said, I will share these slides. So thank you very much for listening. I hope I convinced you that convinced you that my proposition is valid for research and also for practical reasons, that we use that as students, as practitioners, as professors, will always use comparative law, and to know the value of comparative law always helps to read about it, always helps to also see it and envision it in different contexts for legislative purposes, for academic research, for comparative law academic research, and also for practicing law as a consultant, as an arbitrator, or as a lawyer, a foreign lawyer in a foreign country. So I'll be happy to answer any questions. I think we can have
Okay, I think it's question period.
Hi, how are you, Mr. Abdul Malik? I just want to say thank you for giving the lecture on Comparative Law Society. I, for one, did not know anything about it. My name is Sharouk. I'm an LLM student here. I just was wondering, so you practice in the country of Saudi Arabia, or
yes,
where are you?
yes.
That was my question. Are you currently practicing, and where are you practicing this?
I'm not currently practicing. I'm an academic, so I've been teaching for the last 8 years, yes. But I'm not practicing law, yes.
Nice. Thank you, sir.
Thank you.
Oh, and Charles, thank you for organizing all this.
No, it's no problem. As far as international arbitration, I have actually had my own question. International arbitration has evolved a lot since the 1920s and 30s. It started as a more collaborative process and so forth. And now we're starting to see, as actually we saw also at the ISIL conference, pushes for standardization in ethics and other things. What do you think the future of international arbitration using the comparative process is going to be? Are we going to see it become more akin to litigation? Because that seems to be the big difference. It seems like we're looking at more standardization, more things like that. I think you may remember that speaker at the ISIL conference talking about how we need more ethics standards and more standardization of forms and so forth. So at some point, is it just going to resemble a totally separate litigation system if it keeps standardizing itself like this? You understand where I'm coming from?
Yeah, but we have to first differentiate between international commercial arbitration and foreign investment law arbitration. So I think what you are talking about, and the speaker at ASIL was talking about, is foreign investment law, because there is a movement, and it can be, it can be exemplified in the literature itself, where many jurists basically and authors disagree about the best system for reforming foreign investment law arbitration. There is, even in some bilateral investment treaties, and even in some multilateral or regional investment treaties, for example, in the EU, they proposed basically a court system. They proposed a court system for investment cases. So this is in the domain of foreign investment law. There is a debate. There is a unilateral groups on also reforming foreign investment law arbitration. When it comes to international commercial arbitration, I think it will still the same. It will evolve. It will expands. We have different countries issuing different arbitration laws, establishing different centers. And the main focus of these arbitration centers is international commercial arbitration. Many of them, because as you know, for foreign investment law cases, especially if there is bilateral investment treaties, they usually refer the case to exit, or they usually refer to a case to an ad hoc arbitration based on the unilateral arbitration rules. So they will, they have their own mechanisms for foreign investment law cases. Whereas for international commercial arbitration cases, it's either an ad hoc system or an institutional systems. And it's, these basically centers are proliferating around the world. They are expanding. They are, they are hiring more lawyers, etc. So many jurists, because it's basically a useful system to attract foreign investors. It's a useful system to attract foreign traders to come and invest in your country. Then you need to establish these centers, and you need to basically almost all of these centers have their own arbitration rules that regulates basically the tribunals itself. So for me, once you differentiate between the two, international commercial arbitration, foreign investment arbitration, then I think you can see that yes, there are needs for reform, there are requirements for reform in the former, but in the latter, I think it will continue the same with more of these centers and arbitration rules around the world.
More questions? Anyone? We good to go?
I have one
Oh,
question.
we got one more.
So how do different countries determine certain law which governs an arbitration agreement, for example?
It's not different countries, it's basically the parties' agreement. So if you have an international contract, basically international contracts between, let's say, for example, a US party and a Saudi party, then in this contract, they have to decide, they are supposed to decide on the applicable law to both procedure and substance. And if they don't decide, then basically it's the power of the tribunal, the arbitral tribunal, either one arbitrator or three or more, to decide what is the applicable law. This is why Joshua Carton said it's basically the international arbitration practice itself is a comparative law in action. They use comparative law. He even, interestingly, he applied to, to the selection of arbitrators. He said that even for selecting arbitrators, you will still need to use comparative law methodology. I don't know how, but it's an interesting thing, claim that he made in his article, and you can read it. So for them, basically, to read the article, and if they find the law of substance clause ineffective or incomplete, then they have to apply alternative law. They have to consider what is the most appropriate law to be applicable to this issue to resolve it and finalize it and make a binding and effective arbitration award. So for international commercial arbitration, the states are not a party to it in most cases, unless you're talking about procurement contracts, which is a different discussion. But for private contract between private parties who are located in foreign countries, they will either say the CISG is applicable or the UNIDROIT principles, but in some cases they will say also, for example, the civil transaction law in Saudi is applicable, so we will use it. So when they decide on a clause like this, then it might be the discussion for the arbitrators to say, sorry, the arbitrator to check basically whether this law is sufficient to address the contractual issue disputed between the parties or insufficient, and then they have to draw on other sources of law. And what we saw from, for example, in some procedural issues or some substantive issues, they will have this clause that says, for example, X and Y, Z country's law is applicable to substance, but the tribunal has the discretion to use other applicable international commercial laws, meaning here CISG or UNIDROIT. So basically, this gives the tribunal itself a discretion not only to be restricted to apply the civil transaction law that might be outdated or underdeveloped, but they can also apply other international instruments. And as I mentioned in my lecture, which were created by lawyers, which were created by comparative law scholars, mainly from Germany.
Thank you.
Any more questions from the theater and also from the chat? I think we have.
I don't think so.
Okay.
We might wrap it up, and we're about to be out of time anyway.
Okay.
I think that's it.
Thank you, Charles. And as I said, I will share the slides with you by email. And are you going to have a lecture next week with Professor Marco?
Yes, and I'll send you the link to that as well.
Yes,
and,
great. I'd love to attend it, yes. What time is it?
But also, it's our honor to be hosting you here. Honestly, we're very
Thank you.
And you're probably the best speaker to give this kind of a talk that I can think of, because I remember
Thank
in
you.
Washington right off the top of your head. So that's what we see today.
Quick question for you.
Oh, sure.
Sure,
Earlier
yes.
earlier you were mentioning some sort of conference that another speaker attended. What conference was that?
Yeah, that
And
was
how do we
with,
register for that?
Malik
This was
and
institutional transnational law. Sorry, the Institute of Transnational Arbitration. So they have an annual conference held in different cities in the US. So I attended this one was in 2 months ago in Austin. It was 3 days conference. So basically, you should have a membership of this institute, and they organize similar to your society. They organize different conferences and also different events and online webinars on international arbitrations. So they are mainly focusing on international arbitrations. They host people to talk about different international arbitration centers, etc., etc. So this is the institutional transnational arbitration. It's very for me on international arbitration is much better than ASIL. ASIL is more focused on international law, but the transnational institute, the Institute of Transnational Arbitration is more international arbitration specifics, and many actually I met many well-known arbitrators in that conference. It was good to attend.
All right, I guess that's time. It's 12:50. The room reservations.
Okay, thank you very
And-
much. Thank you, Charles.
Yes, yes, it's our honor, and thank you for
Thank
for
you.
this, and I'll to Marco Sashli's upcoming talk. That's going to be on Thursday, and also
Okay.
I'll conclude it. Not only will we have this fantastic pizza, but I'll also be giving out.
Okay, enjoy your pizza. Okay, see you. See you. Bye.
Thank you. Bye-bye. Oh, could you email me the recording?
Sure, yes, I will.
Very helpful. Very, very helpful. Thank you.
Thank you. Bye.
Bye-bye.
Thanks again, Charles.
Yeah, no, it's our pleasure.
I got everyone from the, well, most people from the LLM.